He's one of Nigeria's best-known politicians, having recently served 2 terms as governor of Kaduna State and previously as minister of the Federal Capital Territory of Abuja, as well as the director of the Bureau of Public Enterprises. He's also a co-founding member of the ruling APC party. But now Nasir El-Rufai is a man in the spotlight for all the wrong reasons, accused of massive corruption by his own State House of Assembly, which has investigated him and is now recommended that he be fully prosecuted, along with other officials who served in his administration. The lawmakers allege that the sum of 423 billion naira was siphoned off by the El-Rufai administration, money that was simply spirited away with no projects to show for it, leaving the state horribly indebted. Mr. El-Rufai has denied the charges, calling them a political witch hunt and insisting that he governed with integrity. So what happens next? I'll be joined in the studio by the former EFCC prosecutor, Prince Ben Ikani, who also served as the Attorney General of Kogi State, and by the legislative consultant and public policy analyst, Okereke. Also on the program, plenty of weighty economic matters to discuss here in Nigeria, where there's a real cost of living crisis. As you may know, the Nigerian government has reiterated that there won't be any petrol subsidy payments in 2024. It comes in response to 2 fiscal policy documents making the rounds, which seem to suggest that the government has allocated a large budget for petrol subsidies. President Tinubu, in his inaugural speech in May last year, declared the end of the fuel subsidy regime, saying it was costing the government too much. However, since then, Nigerians have been complaining about a severe cost of living crisis, fueled at least in part by the removal of those subsidies. And of course, we've had strikes and calls for a much higher minimum wage, which suggests that Nigerians are suffering terribly. So is there a sense that the government isn't listening or isn't compassionate? I'll be joined in the studio by the political analyst and chairman of United Nigeria Airlines, Professor Obiora Okonkwo OFR, and by the policy strategist and group CEO of the global investment and trade company, Baba Yusuf. I'm Charles Onyegolu, and this is Arise Prime Time. Now, they accuse him of robbing Kaduna State absolutely blind. Never before in the history of the state has such officially sanctioned theft occurred on such a massive scale. And it's not just Governor El-Rufai allegedly helping himself to the till, but members of his administration pillaging like there was no tomorrow. All this is coming from the Kaduna State House of Assembly, which is recommending that Governor El-Rufai and his deputies be investigated and prosecuted to the full extent of the law. For his part, the former governor has hit back, calling it a scandalous political witch hunt designed to smear his name and insisting that he governed with integrity. Well, if the Kaduna State House of Assembly wanted to get the public's attention with these headline-grabbing allegations, it has. But the question is, beyond the headlines, what is the evidence? And can it stand up to scrutiny in a court of law? Well, for their assessments, I'm joined now in the studio by the former EFCC prosecutor, Prince Ben Ikani, who also served as the Attorney General of Kogi State, and by the legislative consultant and public policy analyst, Okereke. Thank you very much indeed for coming in.
You're welcome.
Let me start with you, and let me start by asking you what you make of what is happening in Kaduna State with this probe into the administration of Nasir El-Rufai on allegations of corruption, essentially money laundering and abuse of office.
Yeah, good evening, Nigerians. As a matter of fact, what Kaduna State House of Assembly has done is actually the proper thing to do.
Well, I was going to ask you that, whether that is the way that things should normally go.
Of course, right. Of course. By virtue of Section 128, they have the power to investigate anything that they are within their ambit of legislation upon. And secondly, by subsection 2B, even corruption is properly mentioned in the Constitution. You know, in a presidential system or democracy, these three arms of government has to be very active. If not, it's a situation we find ourselves in this country where the legislature, especially state assemblies, are being pocketed by governors. That is the proper thing. With proper function of the House of Assemblies or the National Assembly, there is no need for Section 308, this issue of immunity. Because we are expected to monitor, because accountability is the basis of democracy. But what we do in this part of the world is to check our responsibility. I keep on telling people that if laws are to be practiced properly, there is no need for too many laws, because the implementer should know within the ambit of the activities. I'll give you an example. When I was Attorney General, there was a serious murder, and political interests at that time were expecting me to enter a nollie. By the time I addressed the Executive Council for 1 hour, talking, and the governor listened to me patiently, and later on thanked me for saving him from that embarrassment. I don't want to use the instrumentality of nollie prosecution because I'm an Attorney General. Attorney General who knows his discretion, who knows his onion, you sparingly use such powers. That is what it should be. So what State Assembly, Kaduna State Assembly has done is the proper thing to do. Okay. And that is the only way to checkmate the excesses of the executive.
Right. I'm going to come to you in a minute, Chibuzo, but let me ask you this, Prince Ikani. You don't think it's unusual for a State House of Assembly to publicly issue such a damning indictment of an immediate past governor on corruption charges when he hasn't actually been tried and found guilty?
Well, as a matter of fact, whatever they have said is an allegation. It has not been established. And whether or not it is an indictment is subject to interpretation. They don't have the power to, the Supreme Court has held severally, indictment. You cannot indict an institution because you don't have that power. It's only the judiciary that can finally say that. So the indictment is mere pronouncement, as it were. But what they have done is what we call preparatory to criminal prosecution. There must be, for instance, within the ambit of the law, assuming they afforded it to the prosecuting authority like EFCC and ICPC. That is correct. That is good. But equally, within the ambit of the penal code that governs Kaduna State, they have the right to even tell their DPP to go on and fish out the element that they can prosecute at that level. If you are to be somewhere like Kano State, where they have anti-corruption outfit, well and good, it's within their ambit. So what they have done now is mere, postulating from what they have investigating. They cannot actually convict the gentleman.
Okay. Well, let me come to you, Chibuzo Okereke. Thanks for your patience. And in his own defense, Mr. El-Rufai has described the move as a politically motivated hatchet job and roundly denied the allegations. Does it seem like a politically motivated attack to you?
Well, I don't think we can stay here and ascertain the motive. What is important is that under the Constitution, the State House of Assembly sure has the power to conduct this kind of investigation. Section 101 of the Constitution gives them power for self-regulation, upon which they got the authorizing formula for their standing orders. Section 103 gives them power to create standing or special general committees to conduct issues like this. And then Section 128, which is even more apt, gives them power to investigate any public officer situation or circumstance upon which they have the legislative competence to do so. Because they are in the State Assembly, they have that legislative competence dealing with state matters. I'm not sure if the governor appeared in any of the hearings.
Yeah, I don't think he did, although his aides did appear.
And that is the kind of challenge we face when accountability has been murdered, and when a public officer is being prosecuted or even investigated in Nigeria. We believe it's a kind of witch hunt. It shouldn't be. If you control public office then accountability should be a core ingredient. You can be called
Absolutely.
any day, and the constitution to which you swore to handle that office has already prescribed and even set up an institution to look at your activities. Then, but as to motive why they conducted that investigation, they have given their reasons. In terms of legal perspective, they are right. Politically speaking, we wouldn't know why even the 9th Assembly of the Kaduna State House Assembly did not look at some of these things. And this thing exposes us to a lot of things. We have been shouting that there is a lot of imbalance in the executive-legislature relations in Nigeria. And that is a problem. Even at the national level, across all assemblies, we are experiencing that. So we should be able to strengthen the state assemblies to be bold enough to act on the constitutional provision. And like Barrister mentioned, Section 129 actually said that the purpose of investigation by state legislatures or even federal is just to expose corruption, waste, and inefficiency, because they wouldn't have the power to prosecute, but they can make far-reaching recommendations. And that is why sometimes, if not for Section 308, it is good to do it when the person is in an office, so that it can lead to a gross misconduct that can get to impeachment.
That's a good point. I think the former Attorney General raised that point as well. But that's a good point. And also the point that you made about the fact that this should have been done. I mean, there's no reason, because they are empowered to do it.
And there are people that are not covered by Section 308 that they have alleged made the withdrawal. So,
absolutely. Why they didn't do it while he was actually there, because that would have checkmated possibly the money sort of, going awry, assuming it did. But let me come to you, Prince Ikani. This is clearly a case that will need to be proven in a court of law. And as a former prosecutor yourself, I'm sure you will agree that the key to that is not allegations made in the media, but solid evidence. So what happens from here? What will be the process of assessing that evidence, and whose job will it be to investigate and move things on to prosecution?
Yes, thank you very much. As a matter of fact, what they have done is like what we call in any write-up as an introduction. The proper people have the mandate to prosecute at the anti-graft agencies. Now, let me use the word loosely, police, because they have been trained, they have been mandated by the Constitution to investigate, even though what the members did in the State Assembly is equally part of investigation. Even though under Section 29, it empowers them to summon witnesses, call for evidence, oral evidence, whatever. But it's not the one for the scrutiny of the judiciary.
Right.
Must be done by a statutory organization who has been empowered. And before you prosecute, there must be investigation. And this investigation is when they will narrow it down to specific charges. For instance, from the gamut of the entire thing, there are so many count of charges that can be brought out of that investigation. But what they have done is just like a compass leading the ultimate prosecutors to know where to.
Right. Yes. So they'll take the documents that they produce and give it to them, and that will then be the basis from which they'll expand.
Exactly. So what they will now do, the prosecutor will do, is to get nitty-gritty of the points so that they can fulfill the mandate of proof beyond reasonable doubt. But mark you, Charles, proof beyond reasonable doubt is not proof beyond shadow of doubt. There are some inferences that should be done. I heard some people saying the governor must have not, his signature cannot be found anywhere. But in law, inference attack can be a good evidence. Even if there is no specific document where he signed, but where he abused his office. And I keep on telling people that it is high time. This country, we have been practicing democracy for 20-something years now. We should look into Section 308. This immunity, it should not be blanket. There should be special area.
It must have frustrated you so much when you were at the EFCC.
Exactly. When you have special offenses like this that is injurious to the society, it should be one of the exemptions. For instance, do not stop a governor who is on seat being prosecuted or being investigated for offenses as serious as corruption.
Absolutely.
Corruption is eating us raw. So we should attack it frontally.
That's a very good point. Let me come to you, Chibuza, because you understand the way the legislature works, both on a national and on a state level. You've consulted with them a lot. One of the charges leveled against Mr. El-Rufai is that the amount of 423 billion naira was not officially allocated for use. In other words, it wasn't appropriated for special projects, which means that the State House of Assembly did not legislatively designate it in the context of a budget or a spending bill. And broadly speaking, that would make it illegal, wouldn't it?
Absolutely. It's an impeachable, offense under the law. And people have to understand the nature of legislature we run in Nigeria. Nigeria presidential system is designated as a writing legislature, which means the power of the purse lies with the legislature. They make the appropriation. Even though people come on TV and the executive members don't believe that should be the case, because they are trying to impose a different kind of system within our own legislative system. But it's not the right thing. The Constitution prescribes for power of appropriation to lie with the legislature. So the executive makes proposals. Even if you want environment, if you want supplementary budget, the only leeway is that within 6 months where there is no appropriation, you are allowed to spend only on recurrent matters. But you cannot spend on capital expenditure without appropriation. And it's a serious misconduct. But we see these things happening because of capacity gap with the legislature itself, whether at state or federal level. Because if the capacity is there, you are able to track the kind of things the executive is doing, and then you can come by way of motion to draw attention to that issue, and it can be investigated and halted. We have had experience in the National Assembly at the national level, where a president spent over $460 million without appropriation, and when it was discovered, he wrote to National Assembly asking that the matter should be regularized. And they couldn't resolve it because the speaker then asked to set up a committee to go into the archives to know how this type of a matter should be treated, because it's an impeachable offense. And the kind of cordiality that exists didn't allow that kind of a constitutional position to be applied. So you cannot expend without appropriation. And we see governors do these things every day. So the state assemblies need to build more capacity, employ legislative assertiveness to ensure that their own role is being respected. And there's nothing wrong with that, because we swore to that constitution. It has ascribed and prescribed powers to each a branch of government, and everybody should exercise it for the good government of the country.
That's a very interesting point, because it seems, former Attorney General, that they rely on the power of a governor to then act upon what they've done. I mean, I can't say for sure, what the circumstances were, but just from past experience, it seems as if they wait for the governor. When he then loses immunity, he no longer has power over them. The next governor then comes up, and on the basis of whatever he wants, they then proceed against the person.
Yeah, you see, just they are operating this law, especially in this country, upside down. Do you know the intent of the Constitution to even give that immunity temporarily? Is they expect, or the framer thought the kind of members of the State Assembly or even National Assembly will be people with integrity, that you don't need to be pushed before you know what to do. Because what it is, what they thought is that then when there is an infraction like that, first of all, immediately you impeach the governor, he became naked. Then you can now hand him over for prosecution. But now, governors control whatever the State Assembly wants to do. For this, to amazement, when a governor is preparing for election, he's not thinking of himself alone. He'll be paying for the people to go to the assembly. That's what is happening. You can hear somebody say that he bought a form for everybody. This is this country. Well, instead of to mind your own business, be on your own lead, they want to be interfering. That's it. If not, properly, there's nothing wrong with this constitution. It's very, very okay. But there is the implementers, and some of us don't read proper meaning into it.
And that's always been the problem in this country, implementation. Yes. But apparently, Chibuzo, Mr. El-Rufai's deputies turned up in front of that ad hoc committee that was investigating and had nothing to hide or fear, because according to them, their record was unimpeachable. That's what they're saying. Does that suggest that their statements and arguments were not given due consideration over this issue, and that they were not equitably evaluated without bias?
Well, I wouldn't say that, because Section 129 empowers them to summon documents, and indeed they summon those documents, including individuals who administer state affairs at the time. And from the recommendation they have now made, which is subject to further prosecution, because the State Assembly actually has quasi-judicial function, but without finality. So even if the Deputy Governor appears before the committee, she will simply put out a testimony as to whatever, and you and I know what a Deputy Governor is in Nigeria today. Is a truly spare tire in the true sense of it, and doesn't get to sign anything, probably needs permission to even attend function in his or her own village. So I wouldn't rely on the testimony of a deputy governor. I would have loved a situation where the man of integrity himself would demonstrate the value of democracy by appearing before that assembly. It's actually a disrespect to the democracy we practice for somebody not to appear before a constituted authority to answer to questions as to how you govern state affairs which you solicited for. The people didn't go to invite you and force you to lead them. You went around the entire LGA telling them your program, they gave you their vote, you administered their affairs. If questions come up, you should answer it. That's Absolutely. How you demonstrate integrity in a democratic system.
Do you think, Prince Ikani, that Mr. El-Rufai could simply have come forward to the State House of Assembly, given an account of all this in response to their investigation? Or was it enough that some of his deputies, commissioners, and so on and so forth turned up?
No, like my colleague here has properly stated it. You see, if you are talking of integrity, it's not by mouthing it. It should be by demonstration. Even though, personally, I respect El-Rufai from afar. Well, I've been hearing about him. That goes to the point that I say, never judge a book by the cover. If not, for instance, he
hasn't been found.
No, I agree. I'm coming to that. Yes, the most important to show your integrity. Yeah. The moment you are even mentioned, even if they don't invite you, invite yourself. That. Yes, invite yourself. Yeah. That when people say the moment you are investigating somebody, they will run to the prayer and say we want it. No. If I believe in myself, I will even tell you, please bring it. Come and call me. I'll go there. So I would have expected him to work there, even if he was not invited, to give his own side of the story. Not matter of sending people, because the State Assembly must have listened to the people that came, and they said that they must have concluded that the evidence are wishy-washy. As a prosecutor for 30 years, I'll tell you, there are some people who want to confuse you, bring volumes of their statement. It's a trash, because there's no substance in it. Absolutely. You know what you are looking for. Answer the question. That is why I thought he would have gone there personally, even if he was not invited.
That's a good point. And Chibuzo Okereke, I think you mentioned this earlier, but just to drill down on that point further, what about the State House of Assembly members? Did they fail in their oversight duties by allowing, ostensibly, the governor to get away with this during his 8 years in office, assuming their allegations have merit?
Well, unfortunately, it's not a State Assembly investigative report. It's not an allegation. The lawyers and judiciary can call it that, but in terms of the position of our law, it's an important document.
Yeah, but they're recommending that he be investigated and then subsequently
If we are respecting motions and resolutions of the legislature, when they finish that kind of investigation The next thing is for the state prosecuting authorities to take action.
Exactly.
And so I can agree that there is no oversight happening in any state assembly in Nigeria, not to even talk about whether they failed. So and that is why some of us are saying it is good for our democracy to strengthen branches of government with oversight powers. If you suffocate and kill your legislature, the democracy suffers for it. This is not a case of somebody trying to show his powers or that. The state assemblies are not doing any oversight. For instance, the ad hoc committee, they have power to invite El-Rufai, they have power to summon, and if he fails, they have powers to issue warrant of arrest to compel him to come there and testify. So
that's what raises questions in some people's minds about how this actually was conducted. And we don't have all the information.
If you don't use those powers, I have questions as to whether you're ready. So, but based on our engagement with legislature and all, there are serious capacity gap, and I'll plead with Nigerians. Give the legislature support and let it start from leadership recruitment process. I've said that the legislature is not like executive. You don't have deputy, you don't have assistant. In the legislature, as a representative, you are the one to speak on the matter. So your capacity, your training is very key, in delivering on the mandate.
I want to thank you very much indeed. Chibuzo Okereke is a legislative consultant and public policy analyst, and Prince Ben Ikani is a former EFCC prosecutor who also served as the Attorney General of Kogi State. Thank you very much indeed.
Thank you.